the top of the hour, so to respect everyone's time, I'm gonna kick us off here. Welcome to the Mid-Atlantic Tech Bridge Tech Talk, where we're gonna be talking patents. And we've got the awesome team, Mike and Steven here with PPB to share some of their expertise in there. I asked if you have any questions throughout, we're going to, if you could put those in the chat, and then we'll get to those at the end of the presentation. And okay, we're gonna do a quick intro with Mid-Atlantic Tech Bridge and our PA partner. So I'm gonna turn it over to Miss Eileen Brewer.
Hi everyone, I'm Eileen Brewer and I'm sitting in Norfolk, Virginia. We would like everyone to be familiar with who the NavalX Mid-Atlantic Tech Bridge is. They're one of 19 tech bridges across the United States. Their role is to have a venue outside of the Navy base so that innovators and startups can meet with Navy representatives without having to try to get you in the gate. So the Mid-Atlantic Tech Bridge is based in Norfolk, Virginia. We have a QR code on the screen where you can schedule a meeting to meet with the Mid-Atlantic Tech Bridge. You can do it in person in Norfolk, or you can do it through Zoom. We meet on the second and fourth Wednesday of every month from 1 to 3 p.m. Eastern time. You can be coming from anywhere. We're not limiting you to be from the region. You can be from anywhere. We'll set up a Zoom with you. We'll give you a half an hour with the Tech Bridge staff. We have a link where you can give us a little bit of background about who you are and the purpose of the meeting, and then we'll do what we can to help you in your startup. And then we also will be running all kinds of different public events, including our tech talks. And on April 30th, we're going to be doing a full day SBIR workshop from 9 a.m. to 4 p.m. that will be available in person or virtual. So if you go to our Eventbrite, you can see all of our upcoming events and register for them. Next, I'd like to talk about 757 CoLab. We are the PIA partner for the Mid-Atlantic Tech Bridge. We're based in Norfolk, Virginia. This is where the Mid-Atlantic Tech Bridge has a presence outside of the base, is in our offices here. We have 757 Startup Studios, which is an incubator co-working space, no cost to early stage startups who are working on ideation, market research, first customer. You can come and have 6 months free co-working space, mentorship, and programming. The next program we offer is 757 Accelerate. It is a 12-week, once a year accelerator program where we provide training and help you accelerate your business. And at the end, we introduce you to investors. So once you go through that 12-week program, at the end of it, you'll have a public round open and you'll have met between 20 and 30 investors to move your round forward. We are agnostic. You do not have to be DoD type of product. We have consumer products, tech products, SaaS platforms across a wide variety of products. The next thing we have is 757 Angels, that's powered by Venture South. This is experienced investors who are looking for Virginia-based startups to invest in. We also have 757 partnership programs where we do all types of customized programming for different organizations in and around the community and across the region. So if you are looking for someone to come in and provide innovative training on customer discovery or anything related to tech startups, you can reach out to us and we can help you. That's it. Thanks.
All right. Thanks, Eileen. All right. And without further ado, Steven, I'm going to turn it over to you, sir.
Thank you very much, Tina, and appreciate the opportunity to discuss a little bit about intellectual property with everyone today. The basic high-level idea here is that we want to describe what intellectual property is and why it's important for you and your businesses. So obviously, as startups, you'll have different products and services that you're offering, and it may be more or less important to your business, but hopefully this high-level review of intellectual property will be useful to everyone. We can go to the next slide. So a little bit about us. Patent Portfolio Builders is a boutique intellectual property firm, mostly located in Fredericksburg, Virginia, although we've distributed a little bit across the country. I personally have been working with intellectual property for more than 30 years, and I've dabbled in just about everything that there is to dabble in. I worked at the patent office. I've been in large law firms. I did a startup of my own. Interesting story. In around 2002, I did a startup in the subsea fiber optic space, and then the internet crashed, and the need for that bandwidth went away. So, with the money that I got from my options was enough to take my wife to dinner, and I started up this law firm, PPB, in order to provide services for startups and larger companies in the intellectual property space. My background's electrical engineering, pretty typical for intellectual property attorneys to have backgrounds in various technical areas. And so we're going to discuss a whole bunch of things today at a pretty high level. It's a lot to cover in 45 minutes. So I'd encourage you, if we're not able to get to some issues that you're interested in, to check out our website that's listed here on this slide. We've got some resources there for startups and other companies that may be of interest, or also reach out to us, and we would be happy to have a personal conversation with you, some office hours to deal with specific questions that we might not get to today. We can go ahead then. So just to sort of lay out the objectives for this discussion today, as I said earlier, we're going to go through the basics of intellectual property at a pretty high level, but we're also going to do some more diving into what those things really mean, and some more practical applications of intellectual property for startups in particular. How to protect your innovations, and obviously cost is always an issue for startups and any company really, and how to be cost effective when you think about intellectual property. What does intellectual property do for a business? Why should you care about it? We want to get that entrenched in your thinking so that you can consider how that applies specifically to your business. Not everything that I'm going to describe during this presentation is going to be applicable to every business, but is a surprisingly wide scope of applications for intellectual property for startups and larger companies that not everyone necessarily could appreciate if they're not in this space. A little bit about do's and don'ts when protecting your intellectual property. Going to touch on a topic, the federal government, working with the federal government and intellectual property in the context of SBIRs or STTRs. That's a pretty detailed area. And I'll admit, like a lot of things in this presentation, we're just going to cover some really broad topics there. So there's a lot more in that. That could be its own presentation really for an hour or two. And then at the end, hopefully we'll have some time to address any specific questions that you have. So with that agenda in mind, we can go forward. Okay, so like I said, we're going to start by just describing, well, what is intellectual property and what types of intellectual property do you have? One of the questions, I actually put it on this slide because I get it all the time when I talk to startups, is excluding a patent, what are other ways to create IP protection that is valued and effective? And I think largely I get that question because patents are perhaps the most complicated form of intellectual property in some ways, and therefore the most expensive. And from a resource point of view, a lot of startups have to be very cognizant of where they're expending their resources, and sometimes patents just aren't in the budget for them, and sometimes they don't make sense. And we're going to cover some of those reasons today too. But for that reason, we're going to talk about all the various forms of intellectual property so that you have a broad brush idea of what else is out there. So when we talk about intellectual property, there are a couple different categories here. There's a category that is for the protection of implementation of ideas. And by that, I mean, if you come up with an idea to build a better mousetrap, what does that mousetrap look like? What's the implementation of that mousetrap? It's not the idea itself, the concept of the mousetrap. It's, well, how did you build it? What are the different pieces of it? There basically are two forms of intellectual property that protect the implementation of ideas. One is the patent, which we've already referred to a bit today, and the other is trade secret. And in a subsequent slide here in a couple of minutes, we'll discuss in a little bit more detail how these two differ and overlap with each other. But just for the moment, keep in mind that if you want to protect an implementation of an idea, those are the two basic opportunities or mechanisms for you to utilize. But beyond that, there are other forms of intellectual property. For example, branding can be hugely important for a lot of businesses. In fact, some businesses where patents and trade secrets are not very interesting at all have huge opportunities to create brands. Service industries are very typical of this category, right? There may not be a patentable idea or an idea that's subject to trade secret protection, but you may create a brand as you offer goods and services to consumers that they appreciate, that grows in value. So we'll talk a little bit about trademarks. My colleague, Mike, who's here with me today, will be covering that topic. And then continuing on, in addition to implementation of ideas, there's an opportunity to protect the expression of ideas. And that's a subtle difference, but it is in a legal parlance, it's a significant difference. And here we're talking about copyrights, right? So if you write a book, if you write a play, if you create software, these are expressions of ideas rather than implementations, although software is sort of comes between the two a little bit. But you can actually protect the exact expression that you come up with for an idea via copyright, and we'll chat about that a little bit too. And lastly, I want to mention that there are all sorts of different contracts that impact intellectual property. You can have contracts with your employees. You can have contracts with your subcontractors. We're going to talk a little bit about the federal government and SBIRs. That's a contractual relationship as well. And there are typically a lot of different contracts and contractual clauses that can impact your protection of intellectual property. So we want to make sure we're thinking about that at an appropriate time too. So let's go ahead, one more slide. So we'll start with patents, a little bit at a very high level about patents. So what is a patent? If you get a patent that's granted, what you're getting from the government is a time-limited monopoly to exclude others from making, using, and selling the claimed invention, and importing and a few other things along those lines. But the key point here is that a patent is an exclusive intellectual property right in the sense that you can exclude others. It's not a positive right. Some people get confused about this, and they think that when the patent office grants them a patent for their invention, that the patent office is saying it's okay to make, use, and sell the invention for you to do it yourself. But it's not that. It's an exclusive right. So you can prevent others from making, using, and selling what you've claimed and the government has given you a patent right for. Now, when we come to trademarks here in a couple of minutes, it's something to note that unlike patents, trademark evaluation by the U.S. Patent and Trademark Office does tell you a little bit about whether or not you are able to use a particular mark to brand your goods and services. So there's a slightly nuanced difference there, but just for this slide anyway, just remember that the patent grant itself is a right that you would get to exclude others from making, using, and selling your invention. And it's not the patent office saying that you have necessarily the right to do so. Another topic right there that could be a conversation for a whole 45-minute discussion, but hopefully that's a good takeaway for you. Let's go ahead to the next slide. Okay, so this is important, right? It's good for startups to know when you're talking to your patent attorney or whoever you're going to deal with to work on your intellectual property matters, what are the types of US patent applications that you're going to be talking about with them? Basically, in the United States, there are two types, really three. I didn't list the third one here. I'll mention it though. But from a utility point of view, there are provisional patent applications and non-provisional patent applications. And the thing to understand about a provisional patent application is that it's really just like a placeholder. It gives you a filing date for your invention, and it helps to protect you against public disclosure. And in a minute, we'll talk about why that's important. But it's not examined by the patent office, and it's not enforceable against other parties. It's just a placeholder. It lasts for 12 months. And it also gives you the ability to use the phrase patent pending on your products or services, your website, wherever you like, during the 12-month period that it's alive, to inform other people that that you've got the possibility of acquiring patent rights. The other thing to note that I didn't put in this slide about provisional patent applications is that there's no real format requirement because they're not examined and they're not enforceable. The patent office's requirements for what you submit as a provisional patent application are pretty general. They're not very specific. We have submitted some very basic documentation as provisional applications, and we've also submitted documentation that looks just like a non-provisional application, which I'll discuss here in a second. You can have quite a spectrum of filings there. And again, another conversation perhaps for why you would do one versus the other, but sometimes you just don't have the time or the resources to create a very thorough filing. And you can use the provisional patent application to, as this slide says, protect yourself against public disclosure of what you're about to, for example, market or submit to an SBIR. We'll come to that towards the end of this discussion, as a mechanism for helping to protect you against those things. The non-provisional application, which is also called a utility application by a lot of patent lawyers, is what comes later. And this is, well, you can directly file a non-provisional patent application instead of a provisional, but after your 12-month period expires, or during the 12-month period that you have, if you do file a provisional application, you can file a utility or a non-provisional patent application, which is what would get examined by the Patent and Trademark Office, the USPTO. And then if they agree that the patent claims and the application warrant a grant of the patent, the patent that issues from a non-provisional, we get a term of 20 years from the earliest claim filing date. So for example, if you filed a provisional patent application on January 1st of 2024, and then filed a non-provisional patent application on, say, December 31st of 2024, before the expiration of the 12 months, and it was granted subsequently, then that patent would have a 20-year term from the January 1st, 2024 filing date of the provisional. So we can go on to the next slide, I think. So I titled this slide "Starting the Patent Clock." And this is a really important concept for startups, especially to understand. once you file a patent application, whether it's provisional or non-provisional, you start statutory clocks ticking. And for example, I mentioned in the previous slide that a provisional patent application lasts for 12 months, and that starts from the day that you file it. And so you have a period of time during which you've got some rights, or provisional rights anyway. You've got a filing date, but at the end of that period, you either have to file a non-provisional patent application or something else, and we'll talk about in a minute what something else might be, or you forego that filing date. You give up that filing date. And so when I'm advising startups in particular about the considerations involved with respect to when and how to file a patent application, part of what you have to think about is, where am I going to be in 12 months? Where is this innovation going to be in 12 months? Am I still working on it? Is it going to be commercialized? Am I going to be in a position to file a non-provisional patent application in 12 months or not? So it's really important to understand that, yes, it's good to get to the patent office and file patent applications before you publicly disclose things, but you also are starting the patent clock at that point in time. Let's go ahead and move on. So in addition to the United States patent applications, which are, protect your innovations in the US, pretty much every country in the world has their own sort of patent application. Unfortunately for companies, we haven't yet gotten to a point where there is truly an international patent application where you could file one patent application and have it cover your innovation in every jurisdiction in the world. Having said that, they're working on it, right? And so every country has a national patent application, pretty much. I mentioned Germany here, but pretty much any country you can think of will enable you to file a national patent application if you want protection in their jurisdiction. But there also are some areas where there are regional patent applications. For example, the EPO, European Patent Office, covers 26 or 28 European countries. And so you can file there and get coverage in more than just one country if you want to. And it's something to consider depending upon exactly the scope of your innovation and where you're going to be making, using, or selling your products or services. There is also something called a patent cooperation treaty application, which is at the bottom of this slide, a PCT application. It's a little bit like a provisional application in the United States, in the context that it also is not really examined. They do a little bit of a search for those, but it doesn't culminate in an actual granted patent. It's a holding card. What it allows you to do is to defer the 12-month clock, the patent clock, that starts when you file the provisional patent application. I didn't mention this when I was talking about the clock, but it's not just, the clock isn't just starting in the US when you file a US provisional, it's starting across the world. You have 1 year from your first filing anywhere in the world to file elsewhere, typically, if you want to maintain that filing date. The PCT application operates to grant you an extra 18 months on that clock. And a lot of companies use it to defer the decision about whether or not to incur a lot of additional expense associated with filing in all these various countries from 12 months to 30 months. And that can be hugely valuable. So even though it doesn't grant as a patent and it does cost some money, it can be a way to, for example, for startups, to defer that decision until such a time as you've got resources to and better insight into whether or not it makes sense to file patent applications internationally or not. We can move on. Thank you. So that's a little bit about patents, and it's a little bit about patents in 10 to 15 minutes. But we're going to have to transition now to the next form of intellectual property that protects the implementation of ideas, and that's trade secrets. So this is sort of, I've got a slide I'll show in a minute, sort of the exact opposite way almost of protecting the implementation of ideas as opposed to getting a patent. And it can cover really pretty much any valuable business information. The downside to a trade secret, if you will, or its weakness is it doesn't protect against reverse engineering or independent invention. And that's something that a patent will do. So if you're innovating in an area, commercial product, for example, a television, a cell phone, or something that you could pick up at a store and take it apart and reverse engineer it, a trade secret's probably not going to be your best avenue for protecting that innovation because it's somewhat easy to reverse engineer. Similarly, if it's something that you would expect a bunch of people who are sitting on their couch watching television to independently come up with that idea because it's a solution to a problem that that people recognize and can independently invent, trade secrets probably also aren't for you. Having said that, though, there are things that are very interesting with respect to trade secrets versus patents. One thing is that you don't have to go through federal registration or examination. There's no term limit for trade secrets. And there's no question of whether a trade secret will be granted because there's no examination. Everyone has heard of Coca-Cola and the formula of Coca-Cola being a famous example of a trade secret. And it just made a lot of sense because they were able to get much longer protection rather than going the patent route. So if we flip to the next slide, I think I've got my matrix of, yes, this is that slide. So if you compare these two different forms of intellectual property for protecting implementations of ideas, and I'm not going to read through this whole slide. I'm sure Tina will share it with you if you guys want to see it. But you'll see that if you compare the two, they counterbalance each other very nicely. When you look at the different characteristics, some things are applicable for patents and some things are applicable for trade secrets. And if you work your way through this matrix of questions, it becomes clearer anyway, absent talking to an intellectual property attorney, whether you might want to choose patents or trade secrets to protect the implementation of your idea. So I think we can go on and we'll let people read that themselves. Oh, good. This is where I get to take a break and let Mike Loving talk about trademarks and copyrights.
Thanks, Steve. Hi, everyone. Yes, trademarks. As you may be a little more familiar with trademarks, but as you can see, they're a word, words, or a symbol that distinguishes one party's goods or services from those of others, a brand name or symbol or logo, and they're used to prevent others from making their similar goods with a mark that would confuse consumers about the source of goods. So some things I just want to touch on about trademarks is one, kind of the more generic your name is, the harder it will be to get a trademark on something. I'm going to have a hard time getting a trademark on Mike's Used Car Lot or Mike's Restaurant. A great example of a word that was very trademarkable and did very well was Xerox. Xerox then at the end of the day became synonymous with getting made a copy. So when you're thinking about your company name, think that sometimes if it's generic, it's going to have a hard time getting through. And to think about things like that when going for that. Also, as it says, it's used to prevent others from making similar goods. This is to protect the consumers, but also protect you. I know when I go to 7-Eleven in Virginia and pick up a Coca-Cola, it's going to taste the same as a Coca-Cola in California. I have the peace of mind knowing that it's going to be, high quality, safety, and all of that for the products I get. Just like consumers want to know when they have your brand, they have the peace of mind knowing that they're getting the quality and the control that you offer. And for you, you don't have to worry about someone using a name similar to yours or exactly yours and giving a bad product out there, consumers confusing that good or service with your company. So that's very important. Also, you I come from the marketing side and business development background. So what you want to make sure is as you're starting your company, that your company name doesn't already infringe on someone that could be out there. Because the last thing you want to do is spend all your time getting your brand out there, spending money into marketing materials, getting known in the market, and then all of a sudden you get a cease and desist letter. So what you can do for that is you can go to the USPTO website, go to the trademark section, and you can do a trademark search. And as you see on that one slide, it says making similar goods. So the trademark office, they have different goods. And so you'll look on there to find out the service industry or product industry that you fit in. You can put in your company name and see what comes up. From that, then you can kind of make a decision or contact an IP attorney for more advice if you find someone that's very similar to you or you find it wide open and want to continue. But you can do a search on your own. You can hire a professional, but you can also do that on your own. Next slide, please. Trademarks do not require federal registration. However, there are benefits to registering your trademark, including determining whether they are existing trademarks that you might infringe on. And as on our website, as Steve alluded to earlier, we have a startup resource section and have some documentation on trademarks to help break it down for you. The thing about this is, while you don't require federal registration, there are limitations if you don't go that route. While you may be able to use your company name within your state or within your local area, depending on state laws, if someone else has a federal registration, you may be limited on expanding that into other states or other geographic areas. Trademarks is compared to patents is not as expensive, and this is a way a lot of people do start off their journey on IP protection. So it would be smart to maybe look and see if there's any other companies using your trademark out there, using your name, and kind of talk to an attorney after that. So that's kind of what trademarks do and their benefits. Next slide, please. Excuse me. Copyrights. Copyrights, they protect works of authorship, including software and code, from being copied, everything from song lyrics and things of that nature. A blog, if you have a blog, things you're putting out on that. They're not required to be registered with the federal government, but there are benefits. You can sue in federal court and obtain damages. We don't typically do a lot of copyright work, and the reason for that is it's a kind of a simple process for you to file. If you go to the USPTO website, they have a copyright section, and they kind of outline what you need to do to file a copyright. It's usually upload a document and fill out some other documentation, and that can be done rather inexpensive, and that can be done on your own. Next slide, please. Now I'd like to talk about what intellectual property can do for your business. As we all know, we spend the money on a patent. You want to spend it knowing that it is a valuable asset and how it's going to work for you and how it will benefit you and your company. So some of the things that intellectual property can do is assist in executing your business plan. As Steve kind of talked about, that create a barrier to entry for competitors. It stops them from being able to do something that you can do. Convince your customers to buy from you. If you have the patent around that certain piece of technology, it's a feature they love, want, and desire. You can tell your customers, we are the only ones that have the rights to make this. So you can become the industry leader in that certain asset of that certain technology you're producing to convince consumers to buy only from you. Help with marketing efforts. This is near and dear to my heart. As Steve said, once you file a provisional patent or a utility, you can then say you are patent pending. So you can use that for your marketing efforts when you're doing pitch competitions, getting in front of investors. You have the peace of mind of being able to say you're patent pending. And what this kind of shows to investors and kind of shows to the consumers out there is, hey, we're patent pending right now. We're serious about our IP. We've done our due diligence. We think we have something that could be valuable. So therefore, we are filing here. So it kind of puts everyone on notice. Your customers, potential customers, also your investors, and also your competitors on notice that we have something filed and that we're looking to move forward. Freedom to operate makes competitors less likely to assert their IP against your company. That's kind of a defensive strategy play. Next slide, please. Also, as you all may know, directly generate revenue from litigation damages. You have a patent, someone infringes on it, you can take them to court to sue for those damages. IP licensing and sales, obviously you can license your innovation, your software, or whatever you may have to outside parties to use and have that peace of mind that you're protected as well. Help get financing and comfort your investors. This is always great. We like to, this is why we like to do these things specifically. One of the reasons is investors are always going to ask that question about your IP. Do you have any? What are you thinking about it? And it's important to have discussions like this or to have a conversation with an IP professional if you think it might be right to be able to tell that story of why or why not. They may ask you, why didn't you file a patent? And you can be able to tell them, hey, we talked to an IP attorney. They said we, based on what we've created, have a low probability of getting invested, so we decided to allocate our funds somewhere else. Or you can tell them, hey, we talked to an IP professional, we filed a provisional. This is what we have. We're doing our due diligence on everything. And it keeps that ball in play for investors who may then want to, fund your company based on the strength of an IP. It is an asset. It is something that differentiates you from your competitors. So that's very important and key to a lot of investors. So it's great to have that conversation. And while you may not be looking to file or file a provisional, it's nice to start that IP game plan. So when they do ask you those hard questions, you can tell them why you didn't decide to do something, why you decided to start, or why you decided to maybe do it 6 months down the road. Also, you can tell them, hey, while we're pitching, while we're talking, we do think we have secret sauce, but since we've done our due diligence, we know what not to say. When we're presenting, we're not going to give any of those things away. That will start that patent clock that Steve talked about. And finally, recognize your key contributors in your company. You'll get a certificate from the USPTO, a lot of nice frame, and a lot of people like to put those on their walls or to give those to their employees to say thank you as a small thank you and recognition for what they've contributed. Next slide, please. And with that, I will turn it back over to Steve to take the rest of the way.
Thank you, Mike. Appreciate that. So now we're talking about timing. When do I need to consider IP protection? And there are a couple of things to consider in this vein. Pretty much, I mean, the beginning point, right, is when you create something, when you solve a problem, that's usually should be a trigger for you to consider IP protection, at least to start to document what you did and when you did it and why it's important. But after that point in time, you certainly want to consider IP protection before the public disclosure or sale of the innovation that you created. And the reason for that is that public disclosure or sale erodes and in some cases destroys intellectual property protection. I think I've got another slide to deal with that in a minute. But it's really, really important for you to understand that if you're creating intellectual property, particularly patentable intellectual property, you definitely want to get that protected before there's some sort of public disclosure. Mike alluded to this already. There's some funding considerations associated with intellectual property protection. So sometimes our clients and people that we consult with will consider intellectual property protection, not necessarily because they're about to publicly disclose something, but because they want to be able to articulate their intellectual property plan to potential investors and things of that nature. Let's go ahead and take the next slide, please. Public disclosure, right. So this is what I was referring to a moment ago. Some areas of the world have what's called absolute novelty requirements. And what that means is that public disclosure of an innovation prior to filing, for example, a patent application prevents you from getting a valid patent grant. The US is not one of those countries currently, but for example, the EU, generally speaking, is. This is another part of this discussion today that could be a full hour unto itself, because every country treats this issue a little bit differently almost. And I've found even intellectual property attorneys tend to overgeneralize this. But I think for the purposes of today, it's sufficient to understand that public disclosure in some jurisdictions can completely prohibit you from getting patent protection, but that there are other jurisdictions where they grant a grace period and you can obtain patent protection after a public disclosure. So I think that's the takeaway here, right? If you really get into the nitty-gritty with this, and we have with some clients, you literally have to take the public disclosure that you made and surface it to an attorney that's skilled in each jurisdiction that you're interested in, and to try and determine whether or not that public disclosure prohibits you from getting patent coverage in that jurisdiction or not. And these things change, which makes it even more complicated. The laws in these countries on grace periods change. But the best practice is to file early if you can, and file before there's a public disclosure, or keep the secret sauce, the intellectual property, out of whatever it is you're going to disclose. If you need to make a marketing pitch or a pitch to investors and they won't sign an NDA, and I think we're going to get to NDAs in a couple of minutes, try and keep the really important stuff out of that public disclosure. We can take the next slide then. Great. So NDAs, non-disclosure agreements, or also sometimes confidential disclosure agreements, can sometimes mitigate the public nature of a disclosure. Generally speaking, they will. So they're valuable in that context. And then I think in my next slide, I've explained some of the downsides to NDAs and CDAs. But a lot of investors are not going to be super willing to sign NDAs because they're talking to all sorts of innovators across the space, particularly in a particular space that they want to invest in. And they don't want any potential cross-pollination. If they get the two different innovators or two different innovative companies coming to them with the same or similar solutions to a problem that needs to be solved, they don't necessarily want to be accused by one innovator versus the other innovator of cross-pollinating those ideas. And so there's sometimes a reluctance on the part of investors to sign NDAs. Sometimes we have success with investors explaining to them that if they do decide to invest in our company or our clients' companies, that these sorts of NDAs protect their rights as well, and that it avoids destroying the public disclosure issue, or having a public disclosure that destroys IP rights. It avoids starting the patent clock. There are reasons why you can have a discussion with an investor and explain to them that it might be useful for them to sign an NDA, but that doesn't necessarily mean they're going to do so. We could take the next slide then. More cautionary notes about NDAs and CDAs. A lot of times we deal with small companies and individual inventors that feel like NDAs and CDAs are bulletproof contracts that prevent their rights in every way possible. And I just would say to everyone that that's just not the case. They're contracts. Contracts are breachable. The starting point for any contract discussion is the law of damages, and that's what you get out of a contract is you get damages. And so what are those damages? How do you prove them? If someone violates your NDA and discloses the information that you provided to them under the NDA, how do you recover those damages? It's not as easy as people sometimes might believe. State law applies, could negatively impact trade secrets, another probably hour-long discussion right there. If you want something to be a trade secret, you have to keep it secret, as we said before. And so if you disclose it under an NDA with typically a time limit of 3 to 5 years, there are some states that have ruled that the presence of such an NDA destroys trade secrets because you've agreed that at the end of that term that the information can be publicly disclosed. Also, you should know that NDAs in the US are not necessarily treated the same way as NDAs in other jurisdictions. Come back to that grace period discussion with patents. And one example I'll just bring up here is China. In China, typical US NDA is not considered to be sufficient. They have there something called an NNN agreement that I mentioned here. But so in addition to non-disclosure, you've got non-use and non-circumvention types of clauses that you find in those agreements when you're doing business with China. because they don't view non-disclosure as covering non-use and non-circumvention. So you have to be, when you think about NDAs, just understand that they're not bulletproof. They're useful. They're kind of like fences and neighbors. They're not a bad thing to have, but you can't guarantee that they're going to prevent people from taking things. You can go on to the next slide. So that's a little bit about NDAs and contractual things. Capturing IP so we've identified that we've created some IP. What do we do to actually capture it? Obviously, you can talk to an intellectual property professional. That's probably the best way that I didn't put on the slide. But typically speaking, most larger companies and even smaller companies that we work with will have what we call invention disclosure forms. We've got a copy on our website. You can see what one looks like. There are probably 100 billion different versions of that sort of form, but basically it asks questions which capture the basic information associated with the intellectual property. So that you can start to create a record that you can hand over to an intellectual property professional if you get to that point, that gives them a basis for asking further questions. Don't forget about more contractual things. I mentioned them earlier. Employee agreements should have clauses in them about the fact that work that's done in pursuant to their employment with you is a company-owned intellectual property. Same with subcontractors and joint venture agreements and things of that nature. We can move on. Okay. A little bit about, again, another topic that could be an hour, but a little bit about interacting with the federal government. And a little bit of what you'll see in here sort of dovetails with what we've already talked about today in the context of, for example, patents and trade secrets. You'll see some parallels in here. But basically, the first thing that I didn't put in this slide that I really should say is most important is you've got to read the contract that you sign. If you apply for an SBIR or an STTR and you get a grant, you've got to read all of the fine print, or have your representative read all the fine print and make sure they understand it. I put some things in this slide and the next slide that are typical in SBIRs, some of the requirements, just to give you a flavor for that, but it's not exhaustive. Again, this is a semi-complicated little area, but basically, in return for the government giving you money, if your SBIR is granted, they get a limited, and I didn't put the word free, royalty-free, non-exclusive right to use the invention. And they attach certain requirements, and I've got a few of them in here. Again, you've got to read the document, but you've got to do certain things in order to maintain your ownership of the intellectual property. The government will have a license, a non-exclusive license to use the invention, but you will still own the intellectual property unless you violate the agreement. And you see certain requirements in here. I'm not going to really read through them all, but there's a reporting requirement, there's an election requirement, there's a filing requirement, and there are a few other requirements. These are the basic ones. But if you don't follow the agreement here in the SBIR, the government can assume ownership of the intellectual property. It's not likely that that's going to happen. And it really, SBIRs and STTRs are probably the largest mechanism for funding innovation in this country. So I'm not at all hesitant to suggest to companies that they use these mechanisms. It's just a question of making sure you read and understand what you're agreeing to. Let's go ahead to the next one. So some considerations then, based upon what we've already talked about today, if you're going to go down the path of working with the government and doing an SBIR or STTR, you can take certain steps to separate the work that you're performing under the SBIR from the work that was performed before the SBIR. so that it's not subject to those considerations, so that it's obviously not subject to the considerations that or the requirements that we mentioned in the previous slide. You can file a patent application before you file the SBIR, or there also are SBIR data rights that are like trade secrets that you should consult with your attorney about. So I'll leave that at that. Again, a pretty detailed topic, but about out of time for now. So we can go to the next slide, and I'll just thank you all for listening to Mike and I discuss intellectual property today. And I hope that you got something out of this discussion. And as we do with all the startups we work with, we wish you a lot of luck and success on your entrepreneurial journey, and happy to take any questions now.
Thank you, Steve and Mike. That was great. And I really do appreciate you putting some stuff on there. We talk a lot about SBIRs here at the Tech Bridge and with the small businesses we work with. So it's good to see or to know some of the stuff and stuff to look for those. So we really appreciate it. Right now we don't have any questions. Oh, okay. There was one question. Yep, sorry. So Jonathan asked the definition of public disclosure.
Right. So the first thing I'll say in answering that question is, it depends on which jurisdiction again you're talking about, right? A public disclosure in the US might not be a public disclosure in the EU, might not be a public disclosure in Japan. But since I'm a US attorney, I can speak better to that question with respect to the US. Basically, it's something that is available to the public. So there's a classic law case where there was a treatise or a PhD dissertation that was only available in one library in one college, but it was available. The public could go into that library, they could get that disclosure, and they could read it, and that was held to be a public disclosure. So the safe way of looking at this is assume anything that's not under an NDA is a public disclosure that's disclosed to third parties.
Awesome. Thank you, Steve. I'm gonna give it another minute, but while we wait to see if any other questions pop in the chat. This is the last slide for everyone, so if you would like to receive these slides, we ask that you take the really short survey, so you can grab your phone and scan the QR code there on the bottom middle. Joe has actually put it in the chat. You can just click on that. Again, it's like 4 questions, very simple. Again, if you want to schedule a meeting with Mid-Atlantic Tech Bridge team, there's that QR code. And then Eileen had mentioned upcoming tech talks and events. So we've got some other really interesting tech talks coming up on the 31st and February 21st. And then we have our 3rd annual small business workshop, which will be held in person here at the Assembly in Norfolk and virtually. It's a great event. It's been well received every year. It will sell out, so I would highly encourage you to go into our Eventbrite, just how you registered for this, and get signed up for these upcoming events. Mike and Steve, I don't see any other questions. Gerald, do you have anything you want to add?
I just wanted to thank you for a very informative brief. This is definitely an area that for the small businesses that we're looking at, I hope they are really thinking about hard, particularly if they're candidates for SIVers. And I really appreciate the depth that you were able to go into in the short amount of time that we allotted for you.
If we have a little bit of time, can I ask for more specific details on the public disclosure portion? We can personality type people through business analytics, and I've talked about that part. That's a really big deal. You buy something on Amazon, I can figure out your personality type, and then I can adjust my communications to win you over. And I've talked about that publicly relatively recently, but I've never given out the formula we use to distill that information. Am I still within the patentable safety zone?
So I would say yes.
Sweet.
because I don't think you're going to get a patent claim granted that says I'm evaluating data from Amazon based on consumers' behaviors and deriving certain characteristics of that person from those behaviors per se. Like that claim strikes me as overly broad. I mean, you know, you and I could have a discussion at a coffee shop and I could derive just from that discussion, you know, some aspect of your personality or your characteristics. So I think that to the extent there is patentable subject matter there, it's probably in the algorithm that's behind all that. So this goes to my slide where I said, if you've got to make a public disclosure or a pitch to an investor, consider leaving out the secret sauce, right?
Awesome.
So that's my 30-second evaluation of this, but by all means, get a deeper dive from somebody if you have an opportunity.
Yes, sir. Appreciate it. Thank you.
Well, Steve and Mike, again, we really appreciate you taking the time to discuss this really important topic. And as I mentioned to everyone on, we will send out the slides to those of you that take the quick survey. And we'll also have the recording of it posted up on our YouTube channel. So looking forward to engaging with you all in the future, whether through a tech talk or a Meet MATB. Enjoy the rest of your day.
Thank you, Tina. We appreciate the opportunity. We've enjoyed it as well, and good luck to you and all of your folks that are listening.
Thanks,
Yep.
Steve.
Thank you, Tina. Appreciate it.
guys.
And good luck to all the entrepreneurs. If you have any questions, please, or need a consult, please reach out to me. Happy to help you guys. But thank you all for joining us today.